Go when you tell me you're ready.
Sure.
Okay. I'd like to call the meeting of the Board of Directors of the Continuing Legal Education for the State Bar to order. The members of the board are advised of their duty under the State Government Ethics Act to avoid conflicts of interest or the appearance of conflict, and are instructed to refrain from participating in any matter coming before this board with respect to which there is conflict of interest or an appearance of conflict. Does anyone, having reviewed the agenda, does anyone see any conflict or issue that might result in a conflict? If so, please speak now. If not, if you would bring that to our attention as we get to a particular matter, if a conflict should arise. Dixon, welcome. And you came in as I was going through my spiel.
I know what it was, so you don't need to go back to it.
Thank you. I'd like to welcome everyone, the members and guests, to this meeting. I wish that I could say that we're enjoying our time in Pinehurst. Perhaps we can do that in the spring. Let's see. We've had minutes that were presented to you for the January 10 and May 15 meetings. Has everyone had a chance to review those? If so, pending an objection, I would ask for a motion that we approve both sets of minutes.
So moved. This is Adrian.
Adrian, thank you for the motion. Is there a second?
I'll second.
Thank you, Becca. Been moved and seconded. Any discussion? None appearing. All who favor approval of the two sets of minutes say aye.
Aye.
All opposed, like sign. Minutes are adopted. And then Peter, if you would start with the financials.
Sure. I'm going to share my screen just so everybody, we can be looking at the same document. I think that works a little bit easier. So the financials, pretty straightforward this year. I really don't have a lot to point out other than we are a little bit over on office equipment. I think that's probably understandable. We had some stay-at-home needs, work-at-home equipment that needed to get acquired, but we're lower on certainly on a lot of other areas that definitely make up for it. Our postage is a little low, but we do have mailings left this year. We have to mail suspension orders and final invoices for outstanding CLE fees, so that will come up a little bit. I do. Last January, we approved the keeping $50,000 additional in our reserves to pay for the state bar, the new database management software, are part of any new database management software, and that is something that we are now prepared, and I can talk about it when we get to that point in the agenda. I might as well just talk about it now since it's part of my report. We're about to sign a contract with a company to start this project. We demoed 10 or 12 different companies and got into some high-level talks with a lot of different companies for database management and regulatory management, and have said we're very happy to have found a company that's in Charlotte that does regulatory management software. It actually does the regulatory management for the medical board and the Board of Pharmacy and the Board of Nursing here in North Carolina. They also do case management and regulatory management for the Arizona Department of Justice and a lot of other different boards across the country. And the reviews that we got from from our local boards, from the heads of the medical board and others, were glowing, and they recommended this company, which is hard to find people who recommend their database and IT companies, and they were very, very positive about it. So we're in the middle of negotiating the agreement with them. Hope to have that done this week or next, I guess now early next week, and have the project kicked off in October. There will be a certain amount of money due up front in October. And so the state bar is asking the boards any of the boards that reserved funds for 2020 to make their payment out of their budget for 2020 to cover the cost of the initial development of this program. And then going forward, the boards would only be requested to pay their pro rata portion of the annual maintenance and licensing fees. So we're not being asked to pay any more than we reserved, but it is requested that we make that payment this year. And so what I think we need is a request from, or a motion and a approval from the board to approve the financials, and also to approve the $50,000 payment that was held in reserve for the development of the database management software.
So moved.
Now second it. Second.
George, you're muted.
All right. First of all, any questions of Peter regarding the financials? Any discussion of the financials or of the proposal for the $50,000? None appearing. I presume you're ready to vote. All in favor say aye.
Aye.
All opposed, like sign. Matter carries. Thank you, Peter. Next on your list.
Yeah, so the next part of my list is for a PMBR update, and this one should be pretty brief. The PMBR committee continues to meet. This is abbreviation for proactive management-based regulation. Is the idea of training lawyers or offering education to lawyers to try to stem off any sort of grievance issues before they begin to give some proactive training. This committee is meeting. They've actually combined their committee with the cybersecurity committee of this, a newly formed cybersecurity committee of the State Bar, with the hopes that any sort of first module or first training that could come out of this committee would be related to cybersecurity. There's no final plan yet, so I might have some more to report when we meet in a couple of weeks, but they're continuing to meet and try to determine what the best process is for creating a module. They have not come to us to ask for any sort of CLE credit or what would be given, potentially be given as credit for a course that they may create. So we'll have another update in October, but we'll just continue to track that. I think that they want to start small with the pilot instead of trying to have 10 or 12 modules in all these different areas, to focus something on cybersecurity to see what kind of product we can create, if any.
Any questions of Peter on the PMBR matter? I don't believe that needs any action on our part, does it?
No.
All right. Let's see. The management software.
So I talked about that. I would just briefly add that we're really pleased with what this management software is going to be able to do for the bar. Predominantly, most important is that it's going to allow us to have one single database that all of our departments are using, as have one contact. So it should be a universal software for our Office of Counsel, for CLE, for membership, that obviously with certain security restrictions on what can be accessed by different staff members and outside access. But lawyers will be able to log in and see all of their membership responsibilities and CLE responsibilities on one page with a checklist to show what they need to do to remain compliant. I think it will be well received by the lawyers because they now won't have to log into two different places to do their membership and their CLE. There will be a sponsor portal for sponsors to submit information, attendance records or course information, course applications. We just think it's going to really streamline things and make it a lot better. In doing that, starting this process, we don't want to just recreate what we already have. We want to see if what we can make more efficient or what should be changed to make things better. And so part of this process is going to be looking at our structure and looking at our process to see if things should be streamlined or changed to make it better for the staff and for the lawyers. And I think one of the part of that could be potentially changing our fee structure and changing our reporting timelines. And that is something that I recommended to George that we have discussions on in our second session of this meeting on October 7th.
Thank you, Peter. Any questions regarding the software? And Peter, I think you'll provide a little more information between now and the October meeting. Correct?
Yes.
Very well. Thank you. Okay. Deborah,
Yes, sir.
operation of the program.
The report is in your materials where you can see the comparison from 2018 versus 2019. We started a little late this year with our compliance because of COVID, so we are not quite as far along as we would normally be at this time of year, but we have sent all of our show cause notices. This year, not surprisingly, less people got a show cause for hours. Normally it's the other way around, but I guess because people have more time and also they could take courses online, that number went down. However, the number that went up was the report form. So we had 448 show cause notices for failing to return the form, and I think that's the highest number we've ever had. But we're working on getting caught up. We are caught up with where we should be with our invoices. We at this time of year we would be sending the final notices around the 1st of October, and we will be doing that next week. So we've made some progress. And worked hard. So I'm feeling really well about where we are now, in spite of the little setback we had earlier this year. So thank you.
Thank you, Deborah. Why don't we go into Ms. Thompson's matter?
Ms. Thompson is appealing the $75 late filing fee. She advised the exemption committee that she had been on maternity leave in February of this year. And when she returned to work, she submitted her form on March the 29th. The exemption committee denied a request because it's been the board's position not to grant waivers for attorneys on maternity leave unless it was under extraordinary circumstances. So then she appealed to the full board and added a little more information in her letter to the full board that in addition to being on maternity leave, she was also traveling back and forth to Tennessee to help her father, who was terminally ill from cancer. And he did ultimately pass away in March, I believe it was. So she provided more information to us when she submitted her appeal.
To open discussion on that, do I have a motion to either grant or deny her request for relief and a waiver of the $75 late fee?
I
Chairman, with,
move to grant the relief.
and I'll second it.
All right. It's been moved and properly seconded. Now, is there any discussion of the motion? Okay. None appearing. All who favor granting the relief requested, say aye.
Aye.
All opposed, like sign. Then, Deborah, if you would inform her that the board has
Yes,
granted her request, please.
Okay. I will.
The next matter is the report of the Bias and Diversity Subcommittee. In doing that, before I report on that, I would recommend to you an article that was in the ABA Law Practice Today publication entitled "The Most Profound Thing We Can Do Right Now, Uproot Our Own Bias."
George, could I jump in real quick before you give the
Yes.
report? I want to apologize to the board for those members who are not on the CLE, weren't on this subcommittee. I failed to keep you abreast of what was going on, and I shouldn't have done that. And so that's on me, and it's my apologies. In light of that, I think we're going to handle this a little bit differently today. But all of the meetings, the 3 meetings of the subcommittee were on YouTube and are recorded, and I'm going to send the links to everyone so you can review those meetings and watch them anytime you'd like, or even if you were on the subcommittee, you can go back and refresh yourself from those meetings, and I'll send those out as an email to the group as soon as we're off today. But I do apologize for really, I failed to let you guys know what was going on for those of you who weren't on the committee.
Thank you, Peter. The article that is in the Law Practice publication is one that I think every member of this committee would be well served in reviewing and reading. It helped me anyway in seeing things from a different perspective, and one that I think emphasizes the need for bias and diversity continuing legal education. So Peter, if you would maybe jump in and give a summary.
So George formed a subcommittee on bias and diversity, and it met. Let me see if I can get to the page here. Its first meeting was in. Was it 1st of August? Was that the first
It
one?
was July, I think, Peter.
Yeah. Okay, then I get to get to the first one.
Yeah. That one should be on page 55.
Oh, great.
And the report is on 53.
Okay, so the first meeting was in early July. This was we received a letter from James Williams and encouraging us to look at this issue. It's actually we received this letter in May or June, and so we were planning on to look at this issue. Obviously, the events of the summer certainly made it more on top of everybody's minds. And we held 3 meetings of the subcommittee. The first meeting was we heard a presentation from Mr. Williams about the history of racial discrimination in the legal profession in North Carolina. We talked about what other states are doing. There are a handful of states that require some sort of bias and diversity training, whether it's annually or every few years. We talked about what this subcommittee could do in terms of creating a recommendation to come to the full CLE board, and really kind of left it at that. Our next meeting, we went into some overviews of different rule language. For instance, these are what some different some of the states do. New York, Florida have unique language, and then you have a similar kind of standard language that is adopted by Maine, Minnesota, and Oregon to require some training in this area. We saw some sample programs might be out there. Made some proposals. We met again to go over. It seemed to be the consensus of the board, which the board was made up of George as chair. We had Chief Judge McGee and Dixon. We had a state bar counselor. Who else? Who am I missing on the?
Jim Drennan.
And Professor Jim Drennan from the UNC School of Government, retired from the School of Government and AOC, who is a very highly regarded speaker on this topic across the state and does a lot of training for judges across the state on this. And so the subcommittee seemed to have some agreement that they would like to recommend mandatory training. And so we got together finally on our last meeting and came to an agreement on what language might look like. And the language that was settled on, that was agreed to by the subcommittee, is right here. This would create the type of training called diversity, inclusion, and elimination of bias training, and shall mean a program directly related to the practice of law devoted to diversity, inclusion, and elimination of bias towards persons based on race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. Programs may focus on implicit and explicit bias, equal access to justice, serving a diverse population, diversity and inclusion initiatives in the legal profession, and sensitivity to cultural and other differences, among other things, when interacting with clients, judges, jurors, litigants, attorneys, court personnel, and members of the public. This is a kind of a combination of rules that took some language from a couple states and included also the classes of persons that are proposed to be added to the state bars, the preamble to the rules of professional conduct, which is currently a proposed amendment to the rules of professional conduct to make it clear that in our preamble that lawyers should not discriminate based off of these classes of persons. And so we added that into our rule here in the proposal. The CLE subcommittee also made the recommendation, which is here in the minutes, that this training should be required for everyone at an average of at least 1 hour per year, but leaving obviously the discretion to say if the CLE board, which has full discretion on this proposal, would at least at this point could recommend that you have to take a 2-hour course every 2 years or a 3-hour course every 3 years, but not have to take it every year. Their recommendation was just an hour, at least an average of an hour a year, however you were to frame the requirement, but requiring all lawyers to complete at least 1 hour of training in the first year in which this rule would become effective. That was unanimously approved. That motion was approved by this subcommittee and sent as a recommendation to this board to consider. When this board were to consider it and vote, and if the board so chooses to vote and make this proposed rule change, it would have to go to the executive committee of the State Bar Council. They would vote to publish that rule through the Bar Council would vote to publish that proposed rule change, which would go into the journal for a quarter, would come back at the next council meeting and deal with any comments or suggested changes, potentially adopt that rule amendment and send to the Supreme Court for their consideration and approval. So the earliest that a rule change like this would go into effect on North Carolina lawyers would be the 2022 CLE year. So it's not going to be something that would be prepared and able to be enforced in the 2021 CLE year. I talked to George. I don't know if he's going to mention it. It's my recommendation that this board hear this report today, read it, have a discussion on it. But since this is a matter of first impression for many of you, I feel it would be more appropriate to hold off on voting on a recommendation until the next session of our meeting, because I don't want to force a vote here for anyone who hasn't had enough time to consider the implications or the importance of this recommendation.
Thank you, Peter. Peter, would you also mention the consideration of diversity language in the preamble as well as in a rule, and the difference in impact in each of those cases?
So there are 3 items being studied or acted upon by the State Bar's Ethics Committee at the moment. There is the proposed amendment to the preamble to the Rules of Professional Conduct, which is not something that is enforceable with discipline, but it is something that is shows what our shared values are as to relate to non-discrimination against those classes, named classes in the practice of law. And that has been proposed, and is proposed for publication, was published in the most recent journal, and will come back in October for consideration by the Ethics Committee and the Council. It may need to go into a subcommittee for further study. It has certainly received a lot of comments, but that is something that was already published for comment. There's 2 other subcommittees of the Ethics Committee that are studying other potential changes to the Rules of Professional Conduct. One is creating anti-discrimination language in Rule 8.4, which would prohibit discrimination against those classes of persons. Certainly understanding lawyers have their own discretion to take a case or not take a case, but to prohibit that type of discrimination, which would then be something that is enforceable with discipline since it's in the rules. That is one subcommittee. The other subcommittee is studying whether to create a comment to the competence rule in Rule 1.1 to say that cultural, competence, to be a competent lawyer, you also have to be, competent on your, biases and cultural differences and all of these things that are part of what we're recommending education on. That would be part of a lawyer's duty of competence would to make sure that they are competent in this field and area, which our CLE requirement would then track very well with. That is still just that committee met this week again. That subcommittee met the subcommittee met for the first time this week and heard a presentation about implicit bias from Professor Drennan, and so they're going to be meeting again, and we'll see what comes from those 2 committees. But they're going to take very deliberate action and study this very closely. There's certainly a lot of comments they've received about creating discrimination rule in 8.4. There's some support and opposition to that rule, proposed rule, and there's certainly constitutional issues that have to be grappled with and all of that. And they're doing that very carefully and deliberately, and we'll see what comes of that probably sometime in 2021.
Thank you. Any questions of Peter at this point?
Peter, I had a question. I didn't really understand on page 14 where it talks about the 3-year segment and it's just 2 years, 2 hours in that. And then we talk about 1 hour per year. Can you explain the difference in that to me?
So the materials, the kind of proposal on page 14, I'll share it here, was just a draft that I put together as an example of what something could look like if we were to restructure. I drafted this. If we were to look at reorganizing our program to maybe requiring lawyers to not have to report other than maybe once every 3 years, to report 36 hours instead of report 12 hours every year, dividing the bar up into thirds to make the reporting lighter on the staff, but also make it so lawyers don't have to do a report every year. When I drafted this, I put in 2 hours devoted to diversity, inclusion, and elimination of bias training, but that was before this draft and proposal was before the subcommittee made the recommendation that they wanted it to be 1 hour, an average of 1 hour a year. This was more just an example of what something might look like. And again, when this board, our CLE board, full board considers this, they're not wedded to the recommendations of the subcommittee, but that was this was an example of something. And then the CLE, that subcommittee, said they would like it to be at least an average of 1 a year.
So I kind of like that better than the 1 a year. And this is why I'm saying that, not that I don't think this is really important, not that I don't think technology is really important, not that I don't think substance abuse is really important, not that I don't think ethics is really important, but it just seems to me that we're putting in place lots of things everybody has to get every year, and we're pushing out the substantive law training and really limiting the amount of substantive law training they're getting for these specialty items. So that's my biggest concern about it. I think this is an important area, but I think the others are important. But I am concerned that we seem to be moving towards, you got to take this, and this, and the ability to really take something in your substantive area of the law gets kind of left behind.
Other comments? And Judge Keever, one thing we mentioned in our subcommittee meeting was that 1 hour per year, basically that's going to be about 50 minutes of instruction. If we did 3 hours every 3 years, you could have a 3-hour block course that would be able to go into much more detail and delve deeper into the issues, explore other options and approaches to the issues, and that perhaps 3 hours rather would be better than 1 hour.
Well, I agree with that absolutely. And let me ask another question. I don't know if y'all talked about this or not, but would a particular area be eligible for both ethics and bias potentially?
So right now, those bias trainings are eligible for ethics credit. So, but what I envision is creating this as its own category. And so if it's, and that's what we would like to move towards with technology when we develop the new program too, is that they would be their own columns with their own requirements. So you wouldn't be getting both ethics and a bias training from the same hours. Simplified. It's going to be one or the other kind of hour. It's a bias diversity training, or it's an ethics. We're not going to try to make an hour worth 2 different types of credits.
Thanks.
Anyone else?
And I would just point out, George, that if, when and if this board wants to take action, there's no requirement that that this board follows the exact language of the subcommittee's recommendation. It's certainly something that this board could adopt or propose the adoption of the definition of the course, and then with not making, with just saying that this needs to be required and not following the language of averaging 1 hour a year. That's not something that this board has to follow. You don't have to take both of them. You could take the definition and come up with your own recommendation for how often the board this course needs to be taken, or you could leave it a little more general and allow the creation of future language to how this might be required. There's a lot of options there. This was just a recommendation of this subcommittee.
And Peter, correct me if I'm wrong, I think that the new software has something to do with being able to do the 3 hours over a 3-year period. And that was something that would be difficult for us to do with our present software.
Yeah, that's an understatement, George. I think that would be absolutely impossible to switch to right now with our current software. But with being about to be in this development stage of creating our new database and new management program, this would be something we could build rather easily. Having a third of the lawyers do their reporting every year would be easier for the staff. I think lawyers would appreciate it. I do think we should have this conversation. I think our next session on really kind of breaking this out and the potential options is something we should be doing. Because my personal preference, my thought would be that this would be time to look at some of those kind of structural changes. There strikes me to be a little bit of a unnecessary aspect to requiring a lawyer to submit an annual report every year if they've satisfied all of their requirements. If our database and program says you've hit all of your requirements, why do we then require the lawyer to then submit a report saying that they've satisfied all of their requirements, and then charge them a late fee if that's not sent in? So this could be a good time to look at our procedures and our structure, because you don't want to build, if you're going to build it, it'd be great to build it right in when they're doing their first go at this thing, instead of doing it a year and a half down the line.
Deborah, just for information, isn't it fair to say that a vast majority of the reports that you get are basically just signing off on what the bar already has?
Yes, that is a fair statement. I would say 75% of what we get is just signing off that we've got everything correct.
Thank you. Any other questions about this issue?
So there are a couple of items just to point out for those of you who weren't on the subcommittee. I think it's important that the proposed definition does require that the training be directly related to the practice of law. That was important to the subcommittee, that this isn't a general diversity course that's not tailored for the profession. So that's one of the main requirements for the definition, that it be directly related to the practice of law. There was some discussion on the last list of who should be included when we're talking about interacting with outside groups, clients, judges, jurors, litigants, attorneys, court personnel, and members of the public. So, and this is related to the lawyers in their practice of law, their interactions with those people, types of persons. And so we think that the subcommittee thinks that this definition is very broad. It will allow for lots of different types of courses. So it's not you're not having to take the same course every 3 years because there's only one thing that can be taught. There's a lot of different areas that can be taught here, and different types of courses that could happen. We looked at a list of courses that are already available. There's a lot of courses that already teach these items in North Carolina. So I don't think we're going to have a problem of availability for lawyers to complete these requirements. We received support for this from the Bar Association and the Advocates for Justice, along with a lot of other organizations. Those letters are in your materials. So I think the sponsors will jump in support of this requirement as well. The unfortunate thing, if we were to make this proposal, even at the fastest that it could move, it wouldn't become effective until January of 2022. So that's a whole nother year that will pass, but that's as good as we can do. It'll give us time to get lawyers prepared and to get the database designed to be able to track and enforce this requirement.
Any questions from any member of the board? Of our guests who are I think all CLE providers. Are there any comments or questions that y'all have?
Thanks, Joyce. This is Patrick. No comments at this time.
No comment, but in full support of the recommendation.
Thank you. Obviously, you all are going to be the point people, devising the courses, providing the courses, making them available statewide. We're going to depend on you very heavily. Peter had suggested that we not take action on this matter at today's meeting. Is there a general consensus that we will, at this point, table this matter until our October 7th meeting? Maybe I should say, is there any objection to tabling it until that meeting?
I'd also like to give Bert a chance to make comments about this since he was unable to join us today. I can also come up with some other options as it relates to whether this is an annual or biannual requirement, just for the committee to look at, to think about for the next meeting, in addition to the CLE subcommittee's recommendation, if that's what, if you want to have some options there.
And I would recommend to all the members of the board that you review the matters that Peter has already provided us, and just think carefully about what you think would be the best approach to take in addressing this issue. No other comment appearing. We'll table this matter until the second half of our meeting on October 7th. And Deborah, are you going to talk about the legal project management, or that was Peter's, wasn't it?
George, that's the one that we're gonna table that one for future discussion as well.
I'm sorry, I didn't see my own note. I apologize. Then I think it's always a good idea that this board review the state bar's exemption rules, exempting people from the CLE requirements. And I think we have some new matters that have come up in that regard. So, Peter, would you? Sure.
So as this board has seen over the last year, we did, and there are 2 letters in your materials that the board has already seen and reviewed. And so there's no action required there, but one of them is a request from a senior lawyer wanting us to change the senior status exemption to make it a little bit more accessible for lawyers who are still practicing, but in a very limited capacity, but might not be under the direct supervision of someone else. We also received a request from a full-time federal law clerk who was inquiring whether he could qualify for the clerk exemption, which right now is limited only to those clerks in their first or second year of practice. And so this board has already dealt with those in the past, but put on the agenda that it might be a good time to just review our exemptions, make sure that the board is aware of all the different types of exemptions that we have, and see if there's any questions or anything that this board might consider changing. I don't have anything that I would recommend changing right now. I just think it's a good idea for this board to do that on a periodic basis. The reasoning for the clerkship limitation to the first 2 years is really that the clerks are teaching themselves North Carolina law pretty quickly during that time, and a lot of self-study to be able to be a clerk, and they're very busy in that first 2 years of clerkship. Comparing that to a full-time career clerk, I think you see that career clerk needs to stay competent on the changes in the law, and the CLE is the proper place to be able to do that, which to me does strike a difference between those first and second year law clerks coming right out of law school. You see that we have exemptions for members, government members in North Carolina that are government officials, governor, lieutenant governor, council of state, senators, members of the U.S. House, members of the General Assembly, chiefs and vice chiefs of Indian tribes, and officially recognized in North Carolina, and then full-time active duty armed forces members for any calendar year in which they serve a portion in active duty. We have the judiciary and clerks. Judiciary is exempt if they are, if they are required by their office to take an average of 12 hours of education annually. Now, it doesn't have to be 12 every year, but an average of those annually, then they're exempt. Members of the federal judiciary are exempt as long as they are serving in their capacity. And then the law clerks for those first 2 years that they're serving. With the non-resident exemption, if you live out of North Carolina and you reside out of North Carolina, you haven't practiced in North Carolina for at least 6 months, consecutive months, and don't represent North Carolina clients, law teachers. We do have a pretty broad special circumstances exemption that gives this board the ability to give an exemption for unique special circumstances. I did have a question that I will pose with Deborah and Alice later when I was reviewing this. I'll talk about if we have a permanent disability exemption, is that exemption reported to the Office of Counsel or to the administrative committee to act on whether the lawyer should go in disability inactive status for their membership. And so that's something that we'll talk about internally if that's happening. I don't know that we give many permanent disability exemptions at all, but that's something that we'll talk about to make sure that process is being handled. I don't have any recommendations in the exemption field, but if anyone has questions on how this works or comments on what may or may not be deserving of an exemption, then that's what we can talk about now.
Any questions for Peter on the issue of exemptions?
I think the age of 65 as a threshold for an older person's exemption is much too low. Anybody agree with me on that?
I agree with you on that, Dixon.
I'll
Maybe
go
you
with
should
that.
Maybe you should say, does anyone disagree with that?
Luckily, you have that second part of that exemption, which
Yeah. Still, it looks, yeah.
and there are some states that actually, when you hit a certain age, you don't have to do CLE at all, regardless of how you're associating, which I think is dangerous. But
Yeah, I agree with that. It's and being of that age and beyond, I can say this, it's those guys that come in and think they remember what the law is, and they really don't know what the new law is.
Well, in Judge Keever, in our defense, it's the way the law was, and we remember it accurately.
Absolutely. That's the way the law was. That's exactly right.
I'm just, weigh in with the letter that we received from the gentleman that, I'm just going to do a couple of things for my friends and family. And I don't know of a better way to wreck your family than to malpractice on them. And, I just don't think it's a good idea. If they're going to go inactive, they're not going to practice, fine, do that. But to say, because I just dabble in it, I'll just malpractice a little bit as opposed to making a big one, so that's just my 2 cents.
Thank you, Becca. Any others? And anyone want to speak on the other issue? The other letter? Okay.
Well, Dixon, are you simply pointing out that age, or do you think we ought to be actually looking at it?
I was really kind of just jesting.
Okay.
I don't know what do you think? Should we? I mean, the other part of the exemption is if you're not actually providing services, or you're only associating it with someone else.
Well, you know, even the state doesn't make us judges step down until we're 72.
That's right.
Oh.
What was it that Judge Manning said about that? That it's legislative incompetence?
That's also Sarah Parker's favorite phrase. Yeah.
I was thinking it'd be nice to keep it kind of uniform. If that's the age for judges, then it ought to be the age for lawyers too. Although I've had some lawyers that 50's a little old for them to be in there. So.
George, that's something that I can look what other states are doing, what ages they use, and come back and give some information to the board at our next meeting about this topic.
So we can look at that in a couple of weeks, or do you want to wait until our next regularly scheduled meeting?
I could probably have something in the next couple of weeks, but I think we might want to focus our next meeting on the issues that we already have on the table, and we can move this one to a spring discussion.
All right.
There is a little bit of a question whether the whole thing makes sense to say that you're going to be active, but you're not active. You can keep your active status, but only if you're not really active on your own.
Right. Okay. Well, let's plan to look
Although
at that. I'm sorry, go ahead.
I think that it's sort of a, I was going to say, just sort of acknowledging up sort of who they are when they retire, even though they're not anything else.
Marissa, was that you? Would you say it again? You broke up.
I was afraid of that. I've been having trouble. It may just be more of an acknowledgement that when you retire, you're still a lawyer, even though you're not practicing. And it's just sort of to acknowledge that you're not giving up your identity.
I think that's probably in line with that, and Deborah might be able to shed light on it. I think it's more of it was a way for lawyers who wanted to remain active, even if they were not really practicing, but they wanted to maintain their active status. But they didn't want to have to take the 12 hours of CLE for the fact that they don't really practice. Because if they were involved in some sort of counsel or associated with another lawyer, that this could allow them to stay active without having to do those hours.
That's correct.
Okay. Very well. Any other comments on the exemption rules?
Were we going to address the permanent law clerk one? Or?
Oh, yes.
That one I find more troubling. And then, I mean, you're still practicing law. I guess I would want a career law clerk to keep up to speed, but outside of just the regular job. But I know we have a lot of job exceptions too.
And I think that this board, when we looked at it, when it came across, was, we didn't have any discomfort saying this clerk needs to continue to do their CLE. If that's their job, they're not really a public servant in the sense they're not an elected public servant, which is, we give those exemptions to but this is as their career that they need to do this as a duty to stay competent.
And wouldn't they also be able to satisfy a proportion of their required hours by speaking at a CLE course and preparing that course?
Oh, definitely. I'm sure that a lot of the clerks that to get their credit probably are doing courses, teaching courses.
Leah, anything that you wanted to comment about that?
Oh, no, I agree. And that's a good way to get a bunch of credit is teach a course. I mean, I do that. So that's pretty, no, it seems like I agree with what you said, Peter. I don't see the justification on this one to exempt all career law clerks.
All right. Peter, moving to LinkedIn.
Yes. Deborah, was this, I can't remember if you wanted to take this one or if this one's me.
I'll take it. I'll take it. This is an inquiry that we received from Leslie Terry of Kilpatrick Townsend, asking whether they could advertise their CLE program on LinkedIn, and whether that would be sufficient. Our rules don't specifically address how a sponsor is supposed to advertise their course. This really just comes up when you're looking at law firms who want to sponsor a CLE, and that they want to their attendees to get credit. Because we don't allow in-house CLE, they have to then open it up to people outside of their firm. And so that's what was going on here. And she was just asking if this would be appropriate. In the past, we've told people that you could post a notice on your website or post a notice at the courthouse, or just, send letters inviting people to your program. But those are all policy issues that we have developed over the years with how to recommend that people can advertise. This is just a new one. So.
Does anyone have any experience with LinkedIn as to whether or not they think it would be appropriate to advertise a CLE course?
LinkedIn is as much as possible a professional social media. So I don't think there's anything inappropriate about putting it there as opposed to, say, maybe, Twitter or something. But how many people will see it, I don't know. Same could be said of putting it on their website. How many people will see it?
Deborah, was she referring to her personal LinkedIn page or Kilpatrick's LinkedIn page?
Fair point.
I don't know, because she says does advertising a program via a person's LinkedIn feed. So it made it seem more like it was a person versus the firm.
I would believe that more people would follow a law firm's LinkedIn page versus an individual, especially since individuals do change firms all the time.
That's right.
Do we permit, we qualify them for credit if based on specific invitations to individuals to come in from outside the firm?
We ask a question on the application if you advertise the program to people outside of the firm. That's all we ask.
That's the question.
Yes, it's a yes or no answer.
Going to Kilpatrick's LinkedIn page, the only thing they've posted are company photos and jobs.
I think, Adrian, you made a good point. I think even if it was on someone's personal page, which I agree, I think you might want to make sure it's posted on like the True Sponsors page. Mm-hmm. You're much more likely to have someone see it than if it was just a news item on their website, because you'd have to intentionally be going to their website to see anything about it. Whereas if it was on LinkedIn, it might show up in your feed. It might, so I actually think is arguable that it's better advertising on social media than it would be just on the law firm's website. Now, there might be better options than both of those, but if we allow the website, it would seem to me that the social media sharing would be appropriate as well.
All right.
Could you remind me what's in the rule about this? Is there anything in a rule about this?
There's not,
Nothing in the rule about
Dixon.
this.
No.
Okay.
All right. Unless anyone has any other thoughts on that issue, let's move to the effect of COVID on our CLE requirements, whether or not there have been substantial effects.
We just as a primer of what we've already done, as you remember from our earlier meetings earlier this spring, we did delay some enforcement at the beginning of the shutdown period. We were a little later than normal doing notices, show cause, and sending out invoices and those things. And so we definitely gave some more leeway on that, and we're some more leeway, I think, on being a little bit more forgiving with people to make sure that they pay what they need to pay. But there's been some request, and not, I don't know that there's been a true formal request yet, other than some at least one counselor seeking guidance on whether the CLE board is considering reducing or eliminating any of the CLE requirements for 2020 in light of the troubles that we're all going through during the pandemic. My advice or my response when I get those questions is that I don't anticipate there to be any changes, especially since the CLE board did pass a rule that went into effect in January that allows lawyers to get all of their CLE online, all 12 hours. So there shouldn't be an impediment to the lawyers getting their CLE this year. There's a ton of CLE that's out there, even new CLE that we've approved, just crazy amounts of courses that have been approved relating to COVID's effect on the profession and COVID related classes. I don't think there's a shortage of courses. There's on-demand courses available. So I said certainly something we'll bring up to the CLE board, but we didn't anticipate the board reducing any of the requirements for 2020 since lawyers are still practicing and are able to take their courses online. But that's something that, bring to the board for discussion whether there should be any changes or reductions or changes in enforcement for 2020 CLE.
Any comments by members of the board?
I'll make it. Oh, sorry. I was just going to make a comment that, at least this is anecdotally in my experience in my area, consumer law. I mean, I just signed up for what's usually a big annual conference that you go to in person, fly to Boston. And they're offering all kinds of discounted rates. What usually would be $1,500 or more, it's now $200 for legal services. So that's something, and there's tons of hours you can get. And so I think that that's happening across the board too. The cost is going down for a lot of things. And the availability is still there.
I think if you were to ask our sponsors, our providers, those first few months, certainly things got canceled because there was an inability to meet in person, and it was hard to make the switch over to virtual. But the major providers have really made the switch over to virtual CLE to where it's all online, and I don't think we're going to suffer a huge shortage of courses that are available for lawyers to meet their requirements this year.
Is that your experience as well, Julie, Vander?
Yes, lawyers ended up adding 6 extra hours of CLE we normally don't offer. We did that this summer. So, and I know that I see so many wonderful programs offered by the Bar Association, the Advocates, and the Defense Bar. So I think COVID has caused more CLE to be offered to North Carolina attorneys.
That is correct. The Bar Association is spinning up more CLE as well. And, we had the same hiccups that most providers had early during the pandemic, where you had to adjust on the fly for cancellation of in-person programs, but we're back up at full capacity and even exceeding that now. In addition to the complimentary or free hours of CLE we included with our membership starting last year. So that is still going to be available for members. And Lee, I think it was you that mentioned the cost of CLE. You're right. If you would have had a 2-day CLE program in Asheville, there's a lot of direct expenses associated with those types of conferences. But when you're bringing that back in and it's becoming virtual, the cost of the CLE becomes a lot more palatable for far more members, which is advantageous to the profession and the association as an aside as well. So we're not experiencing a shortage of content or the ability to deliver CLE at this time.
Have either of you had complaints from your members about CLE?
I have not received any at all at this point. Questions about whether or not we'll be having in-person CLE in the future, which, we're looking at 2021 before making any type of decision. But no, and again, we don't charge for our CLE, so our insureds tend to be quite happy that there's no expense coming, out of their own pockets. And we added 6 extra hours free to them this year as well. So far the feedback's been positive. Patrick?
We're built a little bit differently, but Josh, the complaints usually involve sort of not knowing, right? When we were making the switch, is this program going to take place 6 months from now, or are we going to have the program in the spring, which are all logistical questions. And so I don't think it's complaints necessarily around access to CLE or quality of CLE. It's just we're in an environment where we could not foresee at some period of time how those repeat annual programs would be delivered. And we have a lot of members who have become accustomed to being in a certain place at a certain time to receive a certain type of experience. But that's starting to settle as well. But no major complaints beyond that.
Thank you.
George, one other thing I have noticed is that the other associations like the Advocates and the Defense Bar, they've offered more CLE and then they're not charging their members because Lawyers Mutual tends to be a sponsor of those. And not that we're doing a whole lot of that, but there have been a good balance of free and fee-based CLEs this year that normally would not exist had COVID not happened.
Any comments from the board or questions? Peter, let's talk about the election.
I take it from the board's silence that you don't want us to change how we're doing our enforcement for 2020. And I don't think it requires any motions or anything. I'll just go forward with that. The State Bar was contacted, what's in your materials, the State Bar was contacted by Senator Warner, Mark Warner's office, asking if the bar would consider granting CLE credit to poll workers, lawyers who volunteer to be poll workers this year to help try to mitigate some of the potential shortage in poll workers due to COVID. We also were contacted by the Board of Elections here in North Carolina and had good conversations with them about this issue. It seems to be in Ohio developed a way to grant CLE credit for lawyers, but it didn't really get picked up by a bunch of other states. Our Alice received this too from the Board of Elections, and we talked about it with our State Bar officers, and there didn't seem to be a huge desire to start opening up CLE credit for non-CLE related activities because that certainly could open up a can of worms for what other types of activities should be considered valuable enough to be given CLE credit, even though they're not really CLE activities. We did mention to the Board of Elections that if there was a training course that lawyers were having to take related to poll worker, that we would certainly be willing to evaluate that in the best light possible to give credit for the hours that they may have had to take for that training. But there was not at this time something that we wanted to offer hours just for serving, time spent working at the polls. And the Board of Elections was understood that, and we did offer to help communicate anything if they wanted to send materials out to lawyers, that we would communicate those materials out and encourage lawyers to consider serving as poll workers, but not the intent was not to offer CLE credit for that, but wanted to bring that in front of the board to see if you had a different opinion, with the understanding that it might be a little late to make all of that happen now for this election, but it might be something that this board would want to consider in the future. If the board would like to consider starting to open CLE credit up for other activities such as pro bono or mentoring or serving in those charitable ways, just with the being careful with the fact that that's going to open up a lot of judgment on what is and what isn't deserving of CLE credit.
My 10 cents. The reason that we have CLE is to stay competent, and I don't see how this helps you stay competent. I mean, it's a great thing to do, and I hope that folks would do that, without having to have the enticement of getting CLE, but credit. But I think it kind of defeats what we're all about.
George, I'm going to recuse myself on this discussion. I am actually volunteered and signed up to be a poll worker on election day.
Me too. Yeah, I'm doing it this year too.
Yeah, I'll be in Durham.
This is Marissa. This is Marissa. Are there other ways that the state bar can honor people who are members of the bar who have served as poll workers and done some of these other things through sort of like recognition for pro bono work that people have done through the year? Can it kind of be pulled into that?
And that's something I can do, Marissa, is I could, we do have, there's organizations that we are affiliated with that recognize pro bono work, that perhaps we could ask them to include service as a poll worker in some sort of recognition, and maybe falls out, not really related to CLE, but there, other ways that they could be honored or commended for their work in the, working at the polls. I think that's a good idea.
Any other thoughts on that? I think it would be appropriate for someone to make a motion to instruct us to respond to Senator Warner's letter, his request.
I move that we respond and indicate that it's not appropriate based on what Becca had to say earlier.
Is there a second?
George, you're muted.
Judge McGee, I saw you move, but I didn't hear. Did you second it?
You're muted, Judge McGee.
You're muted too.
Okay.
I did not second that one.
Okay. Is there a second? Then the motion will die for lack of a second. And then we will move to new business. Does anyone have anything they'd like to bring before the board at this point, or that they would like to have added for the second half of our meeting? None appearing. I will declare this meeting in recess until 2 o'clock on October 7th.
George, can I just remind you that that's the District Court Judges Conference, so I will not be on that meeting.
We shall miss
I'm not
you.
sure I will be either, sir.
Well, we've got 3 members. I don't know if we will be able to have a quorum. Is this something we need to look at another day?
When we did the poll, this was the date that had the most members able to respond, and it was enough to still get us a quorum. It's certainly, I think, due to the nature of the discussion, I don't want anyone to feel that they were unable to participate in what's going to come up. Whether that is seeking to reach out to Judge McGee and Judge Keever about getting comments or thoughts and submitting them, or looking to find a different date. The only issue we run up with is that we're trying to get, if there's going to be a proposal, we want this proposal to be able to be submitted to the bar in October at their meeting in the 3rd week of October. So we can get it gets a little tight if we don't meet sooner than later.
George, I'm fine with y'all going on without me on that issue. I asked my questions and indicated that I think we need to do something, and then I'm very comfortable with the board making that decision.
Judge Crider?
And I will do my best to step out of the other meeting, go from one screen to another, I suppose. And if we think that's, for instance, going to be the first topic on the calendar agenda.
Can we do that?
Yeah, we can make that the first item on the agenda.
Okay.
Are we talking about the October 7th meeting? I'm sorry, I had to go rescue a chipmunk in my laundry room. The cat had it. So I'm sorry, I had to leave, and I never got it herded outside, but it's out. So having said that, are y'all talking about October 7th meeting?
Yes.
Because I got my judges training that I'm supposed to be doing then. It's just a bad time for me.
Yeah, Becca, we talked about that you and I weren't going to be available.
Thank you. I appreciate you including me, Judge Keever. You knew I was doing the chipmunk roundup. So.
Peter, I don't remember all the times that we threw out there as options, but I wonder if there's some tweaking of those options that we could do to work around that for these judges.
Yeah, I'll work on this and see if even if we keep that day, we did a morning and afternoon option there, and there were some that couldn't meet in the morning. But I'm going to try to figure something out, and maybe even if we can work with the judges and look at the agendas to see where we might be able to.
Our problem is we start at 2:30. I mean, conceivably we could be there earlier. But at 2:30 is when the Chief Justice speaks. So
could we maybe move the start of this meeting to 1:30? If everyone would be available at 1:30, and we made this the first agenda item, it might be something that we could get done before you have to pop over for that.
Well, yeah, I was just going to ask, if you're going to do it earlier, do it considerably earlier. I don't mind munching on a sandwich while we're in between my sessions. I can't speak for Judge Keever, but that's the way I feel about it.
Well, I'll reach out to you. I'll send an email to the group to have you look at your schedules for sometime in between 12 and 12 and 2. See if we can start earlier that day, and maybe that's a way we can get everyone to be able to join, at least for this important consideration of the subcommittee recommendation.
Good.
Very well. Then we will recess until October 7th at a time to be determined.
All right. Very good.
Thank you all for your participation in this meeting. And while I know we all wish we could be sitting around the table in Pinehurst and finish everything tomorrow morning, Thank you for your flexibility.
Thank you.
Thank you. Good
Good.
afternoon.
All right.
Peter.